Good afternoon. Today is Monday the 10th of October 2016, and over the last day or so we've been reviewing the submissions that have been filed in relation to the Sajo Oyang appeal against the Ministry of Primary Industries and 26 foreign fishermen that I represent, who have a hearing in the Court of Appeal starting on Wednesday the 12th of October 2016. My clients, being 30 fishermen that I represent, and in respect of this appeal there's 26 fishermen, have applied for relief from forfeiture, seeking relief over a foreign fishing vessel, Oyang 75, that has been forfeited by the Crown for fishing crimes. The interesting aspect about this appeal is that it is a sister ship, and the fishermen didn't work on this particular ship, but they worked on two other ships. One of those other ships actually sank in New Zealand and 6 people's lives were lost. And in relation to the other ship, that was Oyang 70, and in relation to the other ship, Oyang 77, that was also forfeited for fishing crimes. However, that ship's of low value and is insufficient to pay out the crew wages. So the crew have made an application for relief against forfeiture over Oyang 75 for that vessel to be sold to pay their outstanding wages, and also the vessel would also need to pay the cost of the prosecution, the investigation into the fishing crimes, and the captain's fines for being involved in the fishing offending. So it all involves a substantial amount of money. The Sajo Oyang Corporation have appealed a decision of Justice Davidson issued on the 18th of December 2015 at the Christchurch High Court, which granted an appeal to the fishermen that they could apply for relief from forfeiture over the sister ship Oyang 75. In respect of this appeal, I am fighting against the Sajo Oyang Corporation and also against the Ministry of Primary Industries that's represented by the Crown Solicitor's Office at Christchurch. They have opposed our application for relief from forfeiture, essentially on the basis that we should have made an in-room claim over the Oyang 75 vessel before it was forfeited, which in our case would have been impossible. What I wish to do now in video 10 of our series of educational videos on this topic is just to review what is the Crown saying in respect of the illegal submissions that they've filed. So the Crown argument is that the crew have unpaid wages by virtue of a maritime lien in respect of Oyang 77 and Oyang 70. They submit that proceedings for unpaid wages may be commenced against the offending vessel, the Oyang 77 and the Oyang 70, or a sister ship, but not both. They say that the interest in a sister ship arises when an action in rem is invoked. That is when the writ is served, the vessel is arrested, or there is an appearance by the defendant in the Admiralty Court. The Ministry of Primary Industries counsel is saying that they don't oppose the fishermen from establishing an interest in the sister vessel, but we need to establish this interest exists. So it's not really an argument about whether or not they have unpaid wages, it's about the issue to do with whether or not we should have made an in-room claim, which is arresting this ship or having appearances in Admiralty Court about it. They then set out an introduction, and it says as follows, that on the 21st of September 2012 the foreign vessel Oyang 75 and the vessel's fishing gear became forfeit to the Crown under section 255C of the Fisheries Act 1986, following the conviction of 4 officers for the vessel for offences under the Fisheries Act. There was a 5th officer convicted in November 2014. Well, that meant that it took over 2 years for the people to get convicted in relation to the fisheries crimes in relation to that ship, and 5 people were convicted. There were separate criminal proceedings on the 3rd of September 2014 about the foreign vessel Oyang 77, which also became forfeit to the Crown under section 255C of the Act, following the conviction of the master of the vessel for offences against the Act. Section 255E of the Fisheries Act 1996 expressly provides that if property is forfeited to the Crown, it vests in the Crown absolutely and free of all encumbrances. That means that when the vessels are forfeited to the Crown, they don't get any debt associated with it. They get it free and clear. The debt stays with the company, but the Crown just gets the asset. Following conviction, the details of the forfeit property were publicly notified pursuant to section 256 round brackets 2 of the Act. That doesn't mean that my people in Indonesia knew about it at all. It was just notified in New Zealand. The appellant and the second respondents, so the Sajo Oyang Corporation and the Fishermen, have both claimed an interest in the forfeit vessels and have applied to the court, being the Christchurch District Court, which forfeited the vessels, for relief from the effects of forfeiture under section 256 round brackets 3 of the Act, which we have done. That's the main section where you have to apply. The Sajo Oyang Corporation interest as the appellant arises from their ownership of the vessel. The second respondents in this case are 26 fishing crew members. 24 of them worked on Oyang 77, 2 worked on Oyang 70, which sunk in August 2010, and none of the 26 people worked on Oyang 75. The interest claimed by the fishermen is related to unpaid wages. The 24 who worked on Oyang 77 claim in the application for relief that they are owed $4,727,317.80 for unpaid wages. 18 of those crew claims exceed $200,000, which is beyond the jurisdictional limit of the district court, which means that they have to get limited down, which reduces that claim to $4,102,585. There are 2 crew members from Oyang 70 who claim $453,726.72 in unpaid wages, and applying the jurisdictional limit of $200,000 for the district court, the claim would be for 400,000 New Zealand dollars. The estimated value of the vessel Oyang 75 is New Zealand $8 million. The estimated value of Oyang 77 is New Zealand $1,500,000. No issue arises in the context of this appeal that the crew, being the 26 crew members who worked on Oyang 77, have an interest in that vessel for unpaid wages. So the Crown's not disputing that the Oyang 77 crew have an interest in Oyang 77, which is about $4,102,585. The issue that arises is whether, of course, they couldn't pay that out of a ship that's only worth $1,500,000, and we wouldn't get all of that anyway if it was all upheld, because of the costs of selling the ship and all these other cost problems associated with it. It's not really going to do us a lot of good. But anyway, carrying on, and it's because we're reviewing the Crown submissions. So the Crown says the real issue is whether the 24 crew members from the Oyang 77 ship who did not work on Oyang 75 have an interest in the Oyang 75 in unpaid wages. The second issue is whether the 2 crew members who worked on Oyang 70, the one that sank, who did not work on Oyang 75 or on Oyang 77, have an interest in either of the forfeited vessels in unpaid wages. I agree with those issues. They are the issues. Decision of the District Court. In the District Court, Judge Keller concluded that the fishermen had not identified any interest in the Oyang 75 other than by reference to the facts that the Sajo Oyang Corporation, who's the appellant, owned the vessel, and they were the employer of the fishermen, and that the fishermen have a claim for unpaid wages for work on vessels Oyang 77 and Oyang 70 that were owned by the appellant, the Sajo Oyang Corporation. Judge Keller went on to observe that the rights created by the Admiralty Act 1973 are statutory liens, and that the statutory right in action in rem does not create a right which attaches at the time a claim could be made, but rather it arises at a time when the proceedings in rem is commenced. Okay, that's because at the District Court at Christchurch, which is the forfeiture court, Judge Keller, in a decision in July 2015, denied the fishermen the right to apply over the sister ship vessel. I went on to appeal that decision at the High Court at Christchurch, which was on the 8th of September 2015 for the hearing, and then there was a decision delivered on the 18th of December 2015 which upheld our claim and said we could apply over Oyang 75. So I'll just go back to the Crown submissions now. We're up to their paragraph 17, and it says, in the High Court, Davidson J appeared to concur with the reasoning of the District Court, but reasoned that the words forfeit property in section 256 subsection 3 included property forfeit to the Crown which immediately before forfeiture was in the beneficial owner of a party who, but for the forfeiture, would have been liable to a claim in rem. I like that. That really helped us a lot, so I agreed with that. The Crown then go through to set out in their submissions the statutory overview. Paragraph 18 onwards of their decision of their legal submission say as follows: Section 256 round brackets 3 permits any person claiming an interest in forfeit property to apply to the court for relief from the effects of forfeiture. Section 256 round brackets 3 of the Act provides any person claiming an interest in any forfeit property may within 35 working days after the date of the forfeiture or within such further period before the property is disposed of as the court may allow, apply to the court for relief from the effect of forfeiture of that interest. Paragraph 19. The term quotation marks interest is defined in section 2561 of the Act. Prior to the amendment in 2002, section 2561 of the Act provided. Okay, so that's the old version. Interest means, in the case of other forfeit property, a legal or equitable interest in that forfeit property that existed at the time of forfeiture, but does not include any interest, brackets, other than ownership, close brackets, in any foreign vessel or foreign-owned New Zealand fishing vessel or a New Zealand operated fish carrier. The then definition limited the person who could claim relief from forfeiture of foreign vessels to those who had an ownership interest. Prior to the 2002 amendment proceedings for unpaid wages could be heard at the Employment Relations Authority or the Employment Court, the Admiralty jurisdiction of the High Court by an action in rem, and the Admiralty jurisdiction in the High Court by an action in personam. And if the claim did not exceed $200,000 by an Admiralty jurisdiction in the District Court in personam. Paragraph 22 of the Crown submission says, Section 256 was amended in 2002 by Section 3 of the Fisheries round brackets Foreign Fishing Crew close brackets Amendment Act 2002, which provides. Now, I have an issue with the way the Crown has worded this because they have actually left out some words. And it's really important words that they have left out, because they've left out a whole bit at the top which says, these are from my submissions, where it's yellowed, see, that says, in this section, unless the context otherwise requires, and then it sets out the definition of forfeit property, and then it sets out the definition of interest. So it just misses out key words. I'm going to make a note of that. Misses out words unless the context otherwise requires. And it points out that subsection 256 round brackets 1 round brackets little b says, in the case of a foreign vessel, comma, a foreign owned New Zealand fishing vessel, comma, or a foreign owned fish carrier, hyphen, round brackets I, ownership and, round brackets little 2, and interest, comma, as determined by the Employment Relations Authority or any court, comma, that any fishing crew have in unpaid wages, semicolon, and, round brackets little 3, and interest in costs incurred by a third party, round brackets, other than the employer, to provide for the support and repatriation of foreign crew employed on the vessel. Full stop. Paragraph 23 of the Crown submissions. The purpose of amending the definition of interest was to give standing to, inter alia, persons who claimed an interest in unpaid wages to apply for relief from the effects of forfeiture and to give the District Court the opportunity to consider those claims. Well, I agree with that bit. Paragraph 24 of the Crown submissions. As noted above, Section 256 round brackets 3 of the Act gives standing to persons who claim, quotation marks, an interest in any forfeit property to apply, quotation marks, for any relief from the effect of forfeiture of that interest, close brackets. Paragraph 25. On the hearing and application, the Court is mandated to determine the matters prescribed in Section 256 round bracket 6 of the Act, i.e. subsection 6, to include the nature, comma, extent, comma, and if possible the value of the interest in the property. That's like the trial, if you like, because the Court has to determine that. Section 256 round bracket 7, i.e. subsection 7 of the Fisheries Act, provides a list of matters which the Court is required to have regard to, but this list is not exhaustive. The subsection provides the Court with a discretion subject to Section 8, which is subsection 8 of Section 256, to make, in quotation marks, an order or orders providing relief, round brackets, either in whole or in part, close brackets, from the effect of forfeiture on any of the interest determined under subsection 6 of the Fisheries Act. That is in Section 256, subsection 6. That's true, I agree with that. Paragraph 27 of the Crown submissions. Section 256, subsection 8 of the Act precludes the Court from granting relief unless it's necessary to avoid a manifest injustice, or to satisfy an interest that the fishing crew have in unpaid wages. The orders of the Court may include, under Section 256 round brackets 11 being subsection 11 of Section 256, A, the sale or all of the forfeit property, so it can sell some or all of the forfeit property, with directions as to the manner of the sale and dispersal of proceeds. B, the delivery of some or all of the forfeit property to a person with an interest in the property, with or without directions as to payment of a sum of money to specified persons, round brackets, including the Crown, close brackets, prior to such delivery. C, the reinstatement, quotation round brackets, notwithstanding the forfeiture, close brackets, of any interest that was forfeit or cancelled as a result of the forfeiture. So subsection 11, the Court can make an order to sell some or all of the forfeit property and direct how the sale will take place and how the proceeds will be divided up or dispersed between the people who've claimed relief. They can order for property to be delivered to a particular person and give directions about who money should be paid to, including money to the Crown, prior to the delivery of the vessel. They can also order the reinstatement of any interest that was cancelled due to the forfeiture. So they could introduce or reinstate the maritime lien for the unpaid wages over a vessel if it was decided it should be returned to the owner of the vessel, maybe after payment of money to the Crown for its costs for prosecuting them. Paragraph 29 of the Crown submissions continuing. The focus of Section 256 is on the interest in the forfeit property and whether relief should be granted from the effect of the forfeiture of that interest. The legislative intent is clear. They say, A, to have standing, the applicant must claim an interest in the forfeit property. B, in the case of foreign vessels, the interest is limited to 3 types of things. 1, ownership. 2, unpaid wages. 3, third-party costs for providing support and repatriation of the foreign crew. C, the court must determine the nature and value of the interest in the forfeit property. D, the court must not make an order unless, inter alia, it is necessary to satisfy the interest in unpaid wages. And one of the orders the court can make is a reinstatement of the interest, i.e. the maritime lien. I didn't say i.e., but I'm just telling you that. Paragraph 31. It is respectfully submitted by the Crown that the High Court, i.e. Justice Davidson, they say, fell into error by focusing on whether the statutory definition of forfeit property applied. Both vessels are forfeit property. Rather, the focus should have been on the interest the crew members had in the respective vessels. Without an interest in the property, no order can be made to grant relief from the effect of the forfeiture of that interest. This is where I start to have a lot of problems with the Crown guy. The next heading, he doesn't have sections, he just has numbered paragraphs 1 to 43, so it's not a very long submission. But the next heading he had is the second response, i.e. the fisherman's interest arising from unpaid wages. The crew member's interest in the vessel arises from a maritime lien. Maritime liens are expressly recognised by the Admiralty Act 1973. Sections 2 and 5, round brackets 1 of the Act state, maritime lien, without denigrating from the generality of the term, includes a lien in respect of bottomry, respondia, salvage of property, seaman's wages and damage. Quotation marks. In any case in which there is a maritime lien or any other charge on any shipped, aircraft or other property for the amount claimed, the Admiralty jurisdiction of the High Court may be invoked by an action in rem against the shipped, aircraft or property. Paragraph 33. The applicable principles can be summarised as follows. A crew member of a vessel has a maritime lien against the ship in which he or she served for wages ordered to be paid to him or her. B, a maritime lien arises the moment the event occurs which creates it. C, where there is a maritime lien, the right to arrest the ship exists. The maritime lien exists only in respect of the offending ship. Now, he's quoting that from a case called the Banco, B-A-N-C-O, and we'll go back and have a look at that in another video. Because I've got some issues about that too, because you can claim a receivership. Anyway, we'll just carry on with his submissions. E, if the defendant enters an appearance, i.e. that's the people who own the ship, in the action in rem, the action proceeds as an action in personam. If judgment is entered against the defendant, it can be executed against any of the defendant's property within the jurisdiction. And that's the Bianco case again. Okay, well that means if it's within the jurisdiction, so if you had an application at like the Auckland High Court Admiralty in New Zealand, then if you were going to claim your wages by selling the ship would have to be in New Zealand because it has to be in the jurisdiction. So it has to be within the jurisdiction of New Zealand. So if the ship was in Uruguay fishing, where a lot of these ships are, they're not going to do us any good because it will be out of the jurisdiction. So that would be a bit hopeless anyway. Anyway, moving on to F. If no appearance is entered, the action remains an action in rem, operating only against the arrested ship. So what he's saying is that if they entered an appearance, you could just get any of their ships. But if they didn't, you can only get the ship you arrested. So the paragraph 34, he says the Crown basically accepts that the fishing crew have an interest by way of a maritime lien against the vessel in which they were engaged. He's just, we'll move on. Now he's got a sort of another heading, surrogate or sister ship claims, paragraph 35. The background to claims under a surrogate or a sister ship was summarised by Lord Denning in the Bianco, which is a case 1971 square brackets ALL space ER space 524 at page 532 paragraph D. It states, in 1952 there was an international convention held at Brussels. It was held that because of different rules of different countries about the arrest of seagoing ships, some countries like England did not permit the arrest of any ship except the offending ship itself, whereas many continental countries permitted the arrest not only of the offending ship but also of any other ship belonging to the same owner. In the result, a middle way was found. It was agreed that one ship might be arrested, but only one. It might either be the offending ship herself or any other ship belonging to the same owner, but not more. This was an advantage to plaintiffs in England because it often happened previously that, after a collision, the offending ship sank or did not come back to these shores, so there was nothing to arrest. Under the convention, the plaintiff could arrest any other ship belonging to the same owner whenever it came back to England. In New Zealand, the jurisdiction for taking action against a sister ship is by section 5 round brackets 2 round brackets B of the Admiralty Act 1973, which states, subsection 1, in addition to the rights conferred by subsection 1, the Admiralty jurisdiction of the High Court may be invoked by an action in rem in respect of all questions and claims specified in subsection 1 of subsection 4, provided that A, B, this is the main issues in B, and questions and claims specified in paragraphs D to R of subsection 1 of subsection 4 arising in connection with a ship where the person who would be liable on the claim to an action in personam was, where the cause of action arose, the owner or charterer of or possession of or in control of the ship, the jurisdiction of the High Court, round brackets, whether the claim gives rise to a maritime lien on the ship or not, be invoked of an action in rem against that ship. If at the time when the action was brought, it is beneficially owned as respects by all the shares therein, or as on charter by demise to that person, or subsection 2, any other ship which at the time the action is brought is beneficially owned or on charter by demise as foresaid. So the relevant paragraph is section 4, subsection 1, paragraph O. This is your seaman's wages section. Quotation marks. Any claim by a master or member of the crew of the ship for wages under any of the provisions of the Maritime Transport Act 1994 is recoverable as wages or in the court and in the manner in which wages may be recovered. Paragraph 38. In the Bianco, the plaintiff proceeding in rem served a writ and a warrant of arrest on the Bianco and 6 sister ships following a collision which the plaintiff claimed was caused by negligent navigation of the Bianco. The vacation court, literally it says the vacation court, at first instance, and the Court of Appeal considered the equivalent English provision of section 5 round brackets 2 round brackets B, which mirror each other. Section 3 round brackets 4 of the Administration of Justice Act provided, quotations, in the case of any such claim as is mentioned in paragraphs round brackets D to round brackets little r of subsection round brackets 1 of section 1 of this act, being a claim arising in connection with a ship where the person who would be liable on the claim to an action in personam was, comma, when the cause of action arose, comma, the owner or charterer of, comma, or in possession or control of, comma, the ship, comma, and the admiralty jurisdiction of the High Court, may, round brackets, whether the claim gives rise to a maritime lien or the ship or not, close brackets, be invoked by an action in rem against, hyphen, round brackets A, that ship, if, at the time when the action was brought, comma, it is beneficially owned in respects all the shares therein by that person, or, round brackets B, any other ship which at the time when the action is brought was beneficially owned as foresaid. Paragraph 39. In the Court of Appeal, Lord Denning, so this is an English case we're talking about, and there were 2 other justices there, concluded that paragraph 3 round brackets 4 of the Administration of Justice Act, which is an English act, meant that the admiralty jurisdiction in rem may be invoked either against the offending ship or any other ship in the same ownership, but not against both. And he's saying that that's at page 533, paragraph round brackets E, page 537 round brackets little e, and page 540 round brackets little g. Lord Denning went on to observe that jurisdiction in action in rem was invoked not when the writ was issued, but when it was served on the ship and the warrant of arrest was executed. Another judge went further and commented that the writ may be deemed to be served as a result of the appearance by the defendant before the service was effected. Because they're already disputing each other on the same judgment anyway. In Carl Truss versus Wallace and Cooper Engineering, round brackets Littleton Limited, which is a New Zealand case that I've read, Blanchard J, which is Justice Blanchard, said at paragraphs 59 to 60 that he identified 3 conditions that must exist before the admiralty jurisdiction in the High Court may be invoked by an action in rem in respect of what the court referred to as a statutory claim in rem. Alright, so we're going to now get to these sistership things. A, that the plaintiff has an in personam claim of the kind specified in section 4 round brackets 1 round brackets little d to round brackets little r against the defendant. B, that the defendant was the owner or charterer of, comma, or was in possession or control of, comma, the ship in respect of which the in personam claim arose at the time it arose, and C, that when the in rem proceeding is brought, the defendant is the beneficial owner or charterer on demise of the ship against which the in rem claim is made. Paragraph 41 of the Crown submissions, and we're almost finished them. Blanchard J, went on to conclude, which means Justice Blanchard, that's what the J means, it's short for justice, went on to conclude that statutory claim in rem were a remedial procedure or an enforcement right that did not arise until invoked. The judgment at paragraph 63 states, the ability to proceed in rem thus piggybacks upon the proceeding in personam. It is a remedial procedure or enforcement right. It does not arise until invoked, and therefore when the forfeiture happened, there was no proprietary interest to be extinguished by it. Not even an in-okayed right, such as exists immediately when these circumstances have occurred, giving rise to a seaman's maritime lien. The contrast between a statutory claim in rem and a maritime lien is explained in the following passage from the English Court of Appeal in the Henrich Bjorn, round brackets 1985, close brackets 10, space PD, space 44, delivered by Lord Justice Fry. Quotation. It's a long one. But if for the material man may thus arrest the property to enforce his claim, how does his claim differ from a maritime lien? The answer is that the maritime lien arises the moment the event occurs that creates it. The proceeding in rem which perfects the inarchaic right relates back to the period when it first attached. The maritime lien travels with the thing into whoever's possession it may come. The bold liqueur, round brackets, it's an 1851 case, 7 Mu PC 267 at pages 284 and 285. And the arrest can extend only to the ship to the lien. But on the contrary, the arrest of the vessel under statute is only one of several possible alternative proceedings ad fundum to junctum. No right in the ship or against the ship is created at any time before the arrest. It has no relation back to any earlier period. It is available only against the property of the person who owes the debt for necessities. No, necessaries they've got there. And the arrest need not be of the ship in question, but it can be of any ship of the property within the realm. We say jurisdiction in English, say realm. Anyway, the quote carries on. The two proceedings, therefore, though approaching one another in form, are different in substance. In the one case, the arrest is to give effect to a pre-existing lien. The other arrest is only one of several alternative modes of procedure. It offers the greatest security owing to substantial justice in furnishing a security for prompt and immediate payment, end quote. Okay, it's saying, but like what I was raving on yesterday, that arresting a vessel and taking a claim over the vessel gives you the best security. It's the best trustworthy source of getting something. It provides an opportunity to get prompt and immediate payment, obviously because you can sell an asset. Okay, paragraph 42. The applicable principles can be summarised as follows. A claim for unpaid wages may be commenced against the offending vessel or sister ship, but not both. That's what the Crown's saying. An interest in a sister ship arrives when an action in rem is invoked, either when the writ is served on the vessel is arrested, or if there's appearance by the offendant. So the Crown concludes at paragraph 43 that whilst it's accepted that the second respondents, i.e. the fishermen, in respect of the unpaid wages, have an interest in the vessel on which they worked by virtue of a maritime lien, the interest in the sister ship only arises after the proceedings are served the ship is arrested or the defendant enters an appearance in the court proceedings that have started in rem. Okay, so this is what I'm saying. He's saying that the 26 fishermen here that have made claims over Sajo Oyang vessel Oyang 75 can only claim over the vessel they worked on. And if they didn't work on it, they can't claim on it because they can only invoke a maritime lien over the vessel they worked on, not invoke the claim for a statutory lien, because if they wanted to invoke the claim for the statutory lien, they needed to have arrested the ship Oyang 75 first, exercising their rights to a statutory lien that is available pursuant to the Admiralty Act as a right of statute that arises from the unpaid wages being outstanding. And not just file a claim, you'd have to have served the proceedings, which means you have served the paperwork on the other party. It is a little bit tricky doing service. You've got to serve a foreign company, and if they don't have lawyers in New Zealand who will accept service, or don't have an office here, you've got to do the service rules of the High Court Admiralty jurisdiction to the foreign country in Korea, which does take a bit of time. And then you've got to arrest the ship. That's quite exciting. How do you arrest a ship? You know, you hop out on your helicopter with your writ of arrest. You know how the police get an arrest warrant to go to someone's house and arrest them, and they go to the house and kick the door in or something and haul the person out? Well, you can hop on your helicopter with your arrest warrant and go and staple it on the mast of the ship and command the captain to take the vessel to port. All very exciting stuff, but you know, go arrest their vessel and then you know, there's court hearings about it. The Sajo Oyang appeal submissions go further for Mr. Squire. He's going, oh yeah, they've got to determine the wages in the Admiralty Court as well. This will make it like really super hard, you know. So very concise submissions, only 12 pages, but not anything we want to hear. So that was a summary of their submissions, which I've read out to you. So I hope that makes it clear that's what the Crown's grounds of opposition are against us in the appeal on Wednesday.